Hello, this is Derek. Yes, Dancing for Love. That's my video. I'm the director. Sure, I'd be happy to talk about the rights to my video.
You see the viewer numbers and likes on the parody we made of The Bachelor?
Did I see the numbers? I did a whole presentation on it. Did you check your inbox?
My what? Who cares? Those numbers are fire!
Kind of like the video. That's fire. You get it?
Are you guys talking about the video? I can't believe it's doing so well.
That's fire, and I'm gonna make so much money from my video.
Okay, but my cinematic vision, my video. I went to Harvard for my videography degree. That's my video.
But I'm the star of it all. If it weren't for my tap dancing, that video would have been a snooze fest.
Your dancing is fire, but that's my video. It was my expertise in editing that made it.
What is everyone arguing about?
My video! Your video? You mean my video?
Oh, I didn't realize that you guys wrote the script. Without me, there wouldn't even be a video.
I just got off the phone with Netflix. They offered me $1 million to sell the streaming rights for my video.
Your video?
Today I'm going to talk about who owns the copyright in a work. The basic rule is that the author is the default owner of the copyright. For many works, the author is the person who created the work. For example, if James writes a novel, James is the author of that work. Or, in the case of a work prepared by an employee for their employer, the law considers the employer to be the author of the work, and thus the default owner of the copyright. For example, if James's job is to generate advertisements for his employer, the employer would own any copyright in those advertisements. This is referred to as the work made for hire doctrine. Sometimes, determining the creator of the work is relatively straightforward. For example, I'm the creator of this drawing. Believe it or not, I drew it myself. Other times, as in our viral video creators, the question of who's the creator of a work is more complicated. Take the example of movie making. Making a movie takes lots of people. Writers, camera and sound operators, advisors, post-processing editors, musicians, composers, gaffers, grips, and more. How do you figure out who's an author and who's not? Are they all co-authors? Only some of them. One way to deal with this problem is through contract. For example, if all those participants had signed a contract before starting to make the movie, they could have agreed that regardless of who the law might initially label the author of the work, the copyright would be collectively held by all of them, or by a production company that they co-owned, or even just held by a single person. From a legal point of view, the individual participants would be assigning any copyrights they held to whoever they decided should be the ultimate owner. But in many situations, such as our viral video creators, the parties don't even think about assigning rights through a contract before creating the work. In addition, there are other issues in copyright for which the identity of the original author matters, regardless of whether the copyright was subsequently assigned. So even though the copyright can be assigned, knowing the default rules is important. As I described a moment ago, the basic rule for copyright is that the author is the default owner of the copyright. This is statutorily codified in 17 U.S.C. section 201A, which in formal legal language says that copyright in a work protected under this title vests initially in the author or authors of the work. So we know from section 201A that the initial owner of the copyright is the author. But that leads to the next question. Who's the author of a work? Section 201B provides some guidance in answering that question. It talks about works made for hire and explains that in the case of a work made for hire, the employer or other person for whom the work was prepared is considered the author for purposes of this title. Based on this text, we know that for works made for hire, the law considers the employer to be the author of the work. The logical inference then is that when a work is not a work made for hire, the law views the creator as the author. Sometimes, as in my drawing, the identity of the creator is pretty straightforward. Other times, it can be more complicated. For example, sometimes two creators can be joint authors. Section 201 states that the authors of a joint work are the co-owners of copyright in the work. Joint work is in turn defined as a work prepared by two or more authors with the intention that their contributions be merged into inseparable or interdependent parts of a unitary whole. For example, John Lennon and Paul McCartney, or Mick Jagger and Keith Richards, or Bernie Taupin and Elton John. They're co-authors, their songs are jointly written, and it's hard to tell where one's contributions end and the other's begin. A related issue is when the creator isn't actually the person who fixed the work in a tangible medium. For example, if I have another person hold the camera in precisely the position that I describe, and instruct that person to press the record button for me, am I still the creator of the work? Or, to give another example, if I have someone type what I say, am I the creator of the work, or is the person who typed the words into the computer the creator? Generally, the law says that the person who merely transcribes someone else's creative expression isn't the creator. The person who provided the creative expression is the creator. But in between situations in which someone puts pen to paper themselves and someone else merely transcribes what's told to them are lots of gray areas. Another issue that can come up is that sometimes one person will create a work based on another person's work. This gets into the category of what are called derivative works. We'll talk more about this issue later when we come to infringement. But the general statutory rule is that the creator of an authorized derivative work is entitled to a copyright only in the additional creative expression that the derivative work author added. In other words, while it's sometimes easy to identify who the creator of a work is, there can also be challenging issues lurking within that determination. One of the most common situations with authorship arises in the employment context. Consider the following scenario. You're sitting in your office, and your boss comes in and tells you to write a short description of the company's product for the company's website, and to base that description on the product insert. Who's the author of the material you write? You, your boss, the person who wrote the insert. This is a situation in which the works made for hire doctrine comes into play. Typically, works made for hire involve copyrightable expression that's created in the course of an employer-employee relationship. There are two primary statutes to know about when thinking about works made for hire. The first is Section 201B, which states that in the case of a work made for hire, the employer or other person for whom the work was prepared is considered the author. Think about this for a moment. When the work is a work made for hire, the creator is not the author, the employer is. The second important statute is the definition of work made for hire, which is in 17 U.S.C. Section 101. It first defines a work made for hire as a work prepared by an employee within the scope of his or her employment. You can probably imagine common situations that fit into this category, such as our product description example. Other times, it's not so clear whether someone is an employee or a work is prepared within the scope of that person's employment. For example, if you're an attorney working for a firm, but write a novel during your free time, is that novel within the scope of your employment? Section 101 also defines a work made for hire as a work specially ordered or commissioned for use as a contribution to one of several different types of works, including collective works, motion pictures, and tests. If the parties agreed in a written instrument signed by them that the work shall be considered a work made for hire. There are two main parts to this second type of work made for hire. First, the work needs to be specially ordered or commissioned for one of a limited set of specific types of work. These tend to be things that historically have required the involvement of multiple people to create. Second, the parties must agree in a written instrument that the work shall be considered a work made for hire. No written instrument, no work made for hire. unless the work was created in an employee-employer relationship. All of this takes us to the two cases for today. Community for Creative Nonviolence versus Reed, which explores what it means to be an employee for purposes of determining whether something is a work made for hire, and Al-Muhammad versus Lee, which grapples with who is the author of a work that many people participated in creating. The first case, Community for Creative Nonviolence versus Reed, often referred to as CCNV versus Reed, is a 1989 Supreme Court decision that discusses how to determine whether a creator is an employee. James Earl Reed was a sculptor who CCNV asked to create a work depicting the issue of homelessness. The sculpture that Mr. Reed created was displayed in Washington, D.C. in 1985. After the exhibition, however, the relationship between Mr. Reed and CCNV began to sour, with both claiming ownership of the copyright in the statute. Mr. Reed as the statute's creator, and CCNV under the Works Made for Hire doctrine. And that turned on whether Mr. Reed was an employee of CCNV, or whether he was instead an independent contractor. As you read this decision, think about how the court answers this question and why it chooses that approach. The second opinion to read is Al-Muhammad versus Lee. This is a federal appeals court decision involving the question of who the law considers the author of a movie. The movie in this case is director Spike Lee's Oscar-nominated biopic, Malcolm X. The plaintiff, Jeffrey Al-Muhammad, was substantially involved in making the movie, providing extensive input throughout the process. When he didn't receive the credit he thought he deserved, he sued Lee, the production companies, and Warner Brothers, seeking a declaratory judgment for the film to be labeled a joint work and for him to be labeled a co-author of the film, thus entitling him to a share of the profits. As you read this opinion, you may see references to an 1884 Supreme Court decision, Burrough-Giles Lithographic Company versus Sartorati. That case was a copyright infringement lawsuit brought by photographer Napoleon Sartorati over the defendant's unauthorized reproduction of Sartorati's photograph of Oscar Wilde, shown here. In concluding that photograph could be protected by copyright, the Supreme Court addressed the question of whether the photographer, Sartorati, was an author, concluding that as the person who made the creative decisions that resulted in the photograph, Sartorati was its author. One thing to be aware of with Al-Muhammad versus Lee is that this is a decision by the Ninth Circuit Court of Appeals. Thus, while controlling precedent in the Ninth Circuit, it's merely persuasive in other circuits. That said, it provides a clear analysis of the main issue in determining authorship in complex situations and has been followed in other cases. But I encourage you to think about what the alternatives to the approach adopted by the Ninth Circuit might be, and what consequences might flow from those alternatives.